Okay, welcome everybody. Thank you for joining us today for the Dooley & Associates webinar, which is part of our Better Business Learning series. Over the next half hour or so, I'll be talking about how to improve your cash flow and avoid some bad debt. So, if I can get the technology to all agree with me, there we go. So a little bit about myself. My name's Malcolm Campbell. For those of you who haven't dealt with me before, I'm the Managing Partner here at Dooley & Associates. I've been working in law for the last 18 years here in Sydney, and during that time I've helped a diverse range of clients navigate through various legal matters related to their businesses and their private lives. We decided to start our Better Business series with this particular topic because over those years of working with clients and in particular business owners, a common theme is the amount of time, energy and stress that goes into both cash flow and debt management, no matter the type of business. We've seen firsthand the damage it can cause when proper processes aren't in place and how that then impacts on the business in a negative manner. So, based on that experience, I thought I would share our top tips and tricks on how to improve your cash flow and try and avoid those bad debts. If you've got any questions throughout the webinar, please use the panel on the side to put your questions there, and I'll try to get back to you during the Q&A time at the end of the presentation. If we get inundated with them, I will get back to you via email or phone call in the next day or so. I won't respond directly in the presentation. I'm not that capable of multi-skilling, and I'll try and get to them at the end. So in the session, we're going to focus on 4 key areas to help avoid bad debt, which in turn will, of course, improve cash flow. The presentation is very, very practically based. It's not a legal lecture as such. It's all about the practical things that you can implement in business to improve your cash flow and help avoid bad debt. So as you can see there, we're going to talk about effective customer engagement processes, making it all enforceable, manageable and consistent collection processes, and then, if necessary, hopefully not, but if necessary, recovering the debt if required. At the end of the presentation, we'll also share a quick debt health checklist for you to complete and return for your free half-hour consult related to your particular processes and procedures. So please feel free to send that back to us, and we'll get in contact with you straight away. So let's jump right in and get into the presentation. So the first part of it, effective customer engagement. I know it might seem like a fairly straightforward concept, but frequently, far too frequently, we see clients who haven't quite gotten this step right. And if you don't get off on the right foot, everything that flows thereafter is that little bit harder, that little bit more challenging, and of course, therefore, that little bit more costly. So some of the absolute tips that we suggest for helping avoid bad debts is getting to know who your customer is. Go beyond the name of the person you're dealing with. Go beyond even getting their ABN and figure out the legal entity that you're dealing with. I know it's often so hard in day-to-day business of getting through everything you need to get done, and it's often quite an exciting time if you pick up a new client or customer and you want to get straight into providing the goods or the services to that client or customer. But it really pays to slow yourself down, follow an appropriate procedure of gathering information from your client. It really can be as simple as having a very short client details form, and you want to get all the key details. You want to know what type of organisation they are. Are they a sole trader, partnership, company, trust? If they're a trust, what type of trust are they? Are they discretionary trust, unit trust? We want to know who the directors are. We want to know that you're actually taking instructions and orders from someone with authority on behalf of that entity. We're actually quite surprised, even with the clients that we deal with sometimes, that you've got to make sure that you're dealing with the person authorised to engage in that particular legal relationship. So get them to fill in a basic form, figure out what details are important for you, but things like legal name, business name, ACN being Australian company number, ABN being your Australian business number, which are all unique identifiers for companies and businesses. Make sure you get them signing off on those details. Straight away, you can get their contact details set up in your system, and from day dot, you will be communicating to the right people in the right manner. You'll have your contract, which we'll talk about in a minute, in the right name, and you're off to a good start. Conversely, if you don't get that process right, you can often end up chasing your tail when you're trying to recover payment of an invoice. We often see people wanting us to send letters of demand and the like, and they can't even tell us the legal entity that they actually provided the services to. They can give us maybe a name or a contact person, but that's about it. We don't even know exactly where we've got to serve legal proceedings. And once you get to that point, there are a lot of technicalities about valid service of legal documents, which can become very difficult if we don't have all of those details at the outset. Secondly, once you've got those details, you then want somebody to vouch for them. What are they like as a business? What are they like as operators? What are they like in terms of promptness and reliability of payment? So how do you normally do that? Well, of course, in the employment sphere, you'd normally get a referee. You'd get someone to vouch for them. You would call up the former employer or something like that. You can do a very similar thing with new clients, depending on your trade or profession, in getting a trade reference. Now, I appreciate that people aren't going to put forward businesses that are going to say negative things about them, but conversely, it's quite unlikely that somebody's going to go out on a limb for a client or customer of theirs unless they are quite confident in what they are saying. They don't want to be dragged into somebody else's problems, so they're not going to put themselves out there if what they're saying is not correct. But there are other ways of effectively getting somebody to vouch for that business as well. There are independent searches that you can do, such as credit checks through either Baycorp or Vader Advantage, where once you subscribe and become a member of those services, you can do a credit search for them. You can see how many times they've applied for credit, how many times they've been knocked back on that credit, and how many payment defaults that they have. That is a very, very powerful tool that you can use to check their credit worthiness. They often will, those service providers will often provide a credit score as such, and that can be a very, very powerful tool. It's not going to tell you that they're going to be an awesome client, but it will put up a red flag for you if they have had some difficulties with payment terms previously. And information, knowledge, as they say, is power. That information will be very helpful for you in how you deal with that client, how much, what type of credit, if any credit you provide them, whether you're going to allow them to accrue too much in the way of credit or unpaid invoices before you act on it, or whether you're going to do something like COD. Then finally, and probably most powerfully, is getting either a director's or a personal guarantee when you're dealing with entities other than sole traders or partnerships. So if a director or a individual is not going to put their name to the creditworthiness of their business, then that could raise some flags. Now, it might well be that certain clients say it's just not something we do in business, but again, that's useful information. Okay, for whatever reason, right, wrong, or indifferent, they're not prepared to provide the personal guarantee. That tells you something. And it's just that information alone is quite powerful in terms of how you decide to engage with that particular client. And then finally, in terms of the effective customer engagement process, making it hard to owe you money. Use good invoicing practices, have lots of different ways that people can pay you. With the technology available in this day and age, there are so many different ways that you can collect money from clients. It's no longer just cash or check. You can do direct debits where you are pulling the money out of a client's account with their authority, of course, and if your bank provides that type of facility, because not every bank does. You've also then got things like direct debit, so electronic funds transfer. You can take credit card payments over the phone. You can have the EFTPOS terminal in your office. You can use BPay. You can use a direct payment gateway on your website, all of which these days are very low cost. About the only payment methods we don't accept these days are things like diners and American Express, who continue to charge relatively high merchant fees to use those facilities. But again, even there are enough businesses out there for those cards to still be successful. So the bottom line is, don't make it hard to owe you money. Make it as easy as possible for you to collect money from your customers or your clients. Okay, so once we've engaged the customer effectively, we know who we're dealing with, we've got all of the paperwork in terms of their details in place, we can have a think about, well, the next step. And actually, before we move on to that, the little insight that we've got there is, if a customer or a client's not prepared to take a few minutes to fill in your paperwork, then again, you've got to think about whether they're actually a customer worth having. If they're not going to do that for you at the outset, when they're wanting something from you, that may well be a trigger that you're going to have some difficulties with them later down the track. So as I said, once we've got that process under control, we want to put the business in a position where it's all enforceable. Very much like stealing someone else's tagline, if it only saves you once a year, it's a good year. How does that happen? Well, that happens by having a well-crafted set of terms and conditions in place. It doesn't have to be a long-winded, detailed legal contract, although in some circumstances that would be appropriate. The more significant the engagement with the customer, the more valuable the transaction is going to be, the greater the liabilities you might have in terms of the work you're doing, then of course the more sensible it would be to have a detailed, lengthy legal contract. But even for your everyday transactions, having a standard set of terms and conditions, again, is an absolute must. Because as I said, if it only saves you once a year, then it's been worth it. And a lot of the time, by having this documentation in place, it's a disincentive for clients to push the boundaries with your payment terms or try to wriggle out of their obligations to you. They look at what's in place, they look at what they've been issued, and they take that mental approach of, these guys are on the ball, they know what they're doing, I can see that there are going to be various potential consequences for me if I don't comply with them, and it is most likely to help avoid that bad debt. If you do have to have those difficult conversations with clients, then by being able to refer to a document is also very powerful, because it's there in black and white. You don't have to convince them of anything, they can just read it for themselves. It's right in front of them. A good set of terms and conditions should cover all of those things that you can see on the slide there. So you're going to have different ways in which the terms and conditions can be accepted, depending on your business model. And in this day and age, you can have businesses that are entirely online. You never deal with the client face-to-face. You can have all sorts of different arrangements there. Typically speaking, you're going to have what's called a click wrap style term with online businesses, where they cannot proceed further without clicking that they accept the terms and conditions. They have been tested by the courts, and if set up properly, are entirely enforceable. You'll probably see on a lot of websites that you use these days that they give you the option of being able to have that document emailed to you or printed out. That's all about making sure that the customer cannot allege that they didn't have the time or the opportunity to read the terms and conditions before they committed to the transaction. Less and less you'll see now the options of click to go to the end, so you can just accept them, because people will just argue that, oh, I didn't read it, just click go to the end. It made it so easy for me to just move forward. I'm not suggesting making it hard for clients, but however you are providing the terms and conditions, you should be able to prove that you have provided to them. Having a signature on a piece of paper is still the best way to do that, but there are alternatives like the click wrap functions on a website or an email where you can prove that it was attached and sent, those sorts of things. A big tip with terms and conditions is don't put them on the back of your invoices or your receipts. It's too late by then. The contract has already been formed and you are trying to impose post-contractual conditions on that arrangement if it's on the back of your T's and C's or your receipts. It's got to be done up front before the other party has committed to the transaction. So a great way to do them if you're providing quotes is have your quote document set up in such a way that your terms and conditions form a part of it, and to sign acceptance of the quote, they're also signing acceptance of your terms and conditions. There's no one right or wrong way to do it. You just need to make sure that you can prove that you provided the T's and C's to them, and better still, that they expressly accepted them. Of course, the terms and conditions should cover all of the standard things in terms of how the cost or the price is determined. It's got to be clear. If something is uncertain, you will struggle to enforce it later on. You can put requirements in for deposits, your payment terms, as in 7, 14, 30 days, COD, whatever it might be. The point at which delivery of the goods is deemed to have occurred. So again, if you're in the importation business, you've got all sorts of things like X works or free on board or you know, right to their door. You need to define when the goods or the risk in the goods passes to your client. You need to deal with things as well like consequences of default. So what that I don't pay on time? What does that mean to the customer? What's the incentive to them to pay on time? And the obvious one there is interest can be charged. If you don't put an interest clause in your T&Cs, you'll really struggle to get a court to agree that you should be paid interest, at least until you get judgment against the debtor. And then you can also include, subject to them being drafted properly, recovery of cost provisions as well. You want to have a look there in terms of the rights that you have in relation to the goods for an unpaid seller, and that's referred to in other terms as a retention of title clause. So while the risk might pass to the buyer at the time of delivery, they don't actually get title to or rights in the goods until they pay for them. Retention of title clauses have been complicated a little bit by the PPSR provisions, but we can still deal with those and in the appropriate circumstances register your interests on the PPSR. And then if you are unpaid and it is a relevant situation for a relevant type of good, you can, subject to your terms and conditions allowing you to do it, go and get those goods back from the purchaser. You can also deal with things like cancellations, restocking fees, all of those sorts of things. And as I touched on before, what sort of security you might want. That might be that director's or personal guarantee we spoke about, or it could be things like the retention of title clause. These things don't operate at common law. You must have them in your terms and conditions if you want to utilise them as a part of your terms of engagement with your clients. So having those documents in place, both the engagement documents where they've given you your details and then a well-crafted set of terms and conditions that suit your business, not something that's just been copied and pasted from Dr. Google, but something that's been crafted to actually reflect how you do business, will make recovery quicker and cheaper than not having them in place. As I said, they're likely to prevent bad debts, but if there are then slow payers, it gives you a very powerful foundation to move from to recover if necessary. So that brings us to collecting payments. We've gone through the process of engaging with the client, collecting their data, knowing who we're dealing with, be confident who we're dealing with, having a good legal basis upon which we're doing business with them, to then collecting the money. And I think, to be quite honest, this is where a lot of businesses fall down. This is where I think there's a lot of leakage, both in bad debts, but also cash flow impediments. So what I'm talking about there is your debtor days, how long between when you invoice and when you collect. When you don't get this step 3 right, which is probably the easiest thing to fix up in a practical, non-legal sense, but when you don't get these things right, it makes it a lot harder. So my number 1 tip really here is the one at the top, pick and stick. What do I mean by that? What I mean by that is have a customer engagement process, which we spoke about before, and then a formal legal engagement procedure where you're issuing the T's and C's, and then an invoicing process that works for your business. It's got to reflect how you do business, whether it's all going to be pay up front, COD. That's a great way to improve cash flow, but it doesn't work for everybody. Some people are going to require a deposit. If you're in the building game, you're going to want to try as best as you can, not always possible, but you're going to want to try to cover the cost of the inputs you're going to have to buy for the job. You might want staged payments. Again, that can work quite well in IT, building, a whole range of different service provisions there. But whatever works for your business, make sure that you set it and that you stick to it. Where you start jumping around with your engagement and invoicing and collection processes, you will leave money on the table. It's always the one that you make the exception for that ends up burning you. I've experienced that personally, and I've seen it time and time again for clients. You need to pick and stick. Doesn't mean you can't tweak those processes after bad experiences or things that open your eyes to a situation where it could have been handled differently or better. Doesn't mean you can't change, and you should always be reviewing and making sure that things are working as best as possible, but just training yourself and your staff to stick to those processes. The next one, who owes you money? Look, I know that sounds like a silly point to raise, but there are plenty of businesses out there that don't know who owe them money. If you don't know who owes you money, how can you proactively go and collect it? A simple way to deal with that there is running whatever your payment terms are, 7-day, 14-day, 30-day debtor reports. Out of all of the accounting systems that are available these days, you will all of them will be able to produce very simple debtor reports. They'll normally give you a snapshot of your, say, 30, 60, 90, 120-day debtors, depending on the type of settings you've got in the system. Print that or look at that on screen religiously. Because if you don't know who owes you money and you don't know what point in that cycle they are in, you can fall into the trap of providing further goods or services to that client whilst they still owe you a substantial amount of money. It happens all the time. You're eager to do the business. You kind of forget about where they're at because you haven't been monitoring the debtors. You provide further goods or services to them, even to established clients, and all you're doing is digging a deeper hole with that particular client. So whether it's you or one of your staff, you need to be regularly monitoring who your debtors are and where they're at in that debt cycle. Once you know that, again, knowledge is power, you can act on it. Prompt action gets the best results, and it's really that whole bell curve of satisfaction. If you can invoice and then act on it and collect as close as possible to the provision of the goods or services, you are more likely, or you invoice and chase the payment, you are more likely to collect whilst you are in that peak period of client satisfaction. So the longer you wait, the less likely it will be that you will collect, because that satisfaction declines over time just through the natural expiration of time. It's no longer as urgent or no longer as important to the customer. That immediate need that they had has been dealt with. There's no longer that nexus with the need to pay. So the longer you wait to act, and you can only act if you know who owes you money, the longer you wait to act, the less likely you are to recover. So how do we do that? Well, again, software systems these days, accounting systems will have collection letters. You can automate those processes. So at whatever interval is appropriate for your business, send out automated collection letters. It's amazing how effective that sort of passive communication can be. But don't wait too long. As I said, the longer you wait, the less likely you'll collect. And in the meantime, you're effectively financing their business because you've paid your staff, you've paid for your inputs to provide that good or service to them. They haven't then paid you. The next one is take their money. And the short and simple answer is take it no matter what. Sometimes I have clients asking me whether taking a check for a part payment is an admission that they don't owe the balance of the money. The short answer is no, take it. Take it in whatever form you can get it. Bank the check, send them a short email thanking them for the part payment, noting you look forward to the receipt of the balance of the payment. Take it in installments if you have to. Obviously get something in writing with them where they acknowledge that they're going to pay by installments, and rather than just giving them a grace period, so a month, 2 months, 3 months, where you're just waiting till the end and hoping that they're going to pay, make them pay smaller amounts as you go, weekly, fortnightly, whatever it might be, but you're seeing some good faith there. If they're asking you for some leniency, if they're asking for that from you, then they've got to give you something back in return. And if that's small, frequent payments, then that's a great way to do it. Getting it in writing from them is also a double win for you because one, you've got an acknowledgement of the debt, so they can't later contest that they actually owe you that amount. Plus you've got a commitment from them that they will pay in those installments. And again, the easier you make it to take their money through all those different methods of payment we spoke about before, the more likely it is that they will stick to those installment agreements. And then finally, toughen up. What do I mean by that? Well, you've put all of these things in place. You've gone to the effort of collecting the relevant data. You've gone to the effort of putting a good set of terms and conditions in place and had them sign it, or at least you can prove that they have received it. You've invoiced, you've sent follow-ups, you've done all the hard work. Don't go weak at the knees right at the end because you're worried about damaging the client relationship, or you find conversations around money a little bit icky. Just toughen up, take a deep breath and have that hard conversation with them. If it means picking up the phone and having a conversation, then do it. Because the bottom line of it is, if you go to all of that effort, why do you expect a debtor to abide by it if you're not prepared to do it yourself? So it's one thing to be frustrated with a debtor that hasn't paid, but why do you expect them to pay within your terms if you're not going to enforce them yourself? So take that tough stance and you'll be amazed, without doing it aggressively, you'll be amazed at the response that you do get. And then look, finally, if you do get to the point where despite all of your best laid plans, you still haven't been able to get the client to pay voluntarily, then you can recover it. You can go the passive all the way through to the quite aggressive step in recovering. What do I mean by passive? Well, passive recovery is doing things that will, or taking a stance that will increase the likelihood of payment. So one of them might be COD. If they need what it is that you have, then you can say, I can't deal with you further until you bring your accounts up to date and you're now on COD. Again, taking that tough stance. Another quite effective passive recovery method is using the previously mentioned credit rating authorities function that they have of reporting a payment default. It will be very, very difficult for them to get credit. And when I say credit, it's not necessarily just a loan. It can be a credit card, it can be an interest-free TV, it can be a vehicle lease, whatever it might be. It might even be just the account at Bunnings, because I'll tell you now, Bunnings will do credit checks. Report the payment default, because when the credit check is then done, they'll see there is a payment default on their credit history, and quite often they will refuse the provision of that credit until that default is removed. What does that mean for you? It means for you that the customer is more likely to come back to you and try to sort out that default. That's why we refer to it as a passive recovery tool, because you're not actually chasing it as such. You're sitting back waiting for them to come back to you. That works quite well for smaller debts because it's obviously time-consuming, stressful and costly to commence legal proceedings. If the debt isn't of a particular large enough size to go through that process, the payment default route can be very, very effective. So if that's not appropriate, or you want to be more assertive with it because it might be a larger debt, then there are active recovery steps. So the most frequently used active recovery step is a statement of claim in either the small claims division of the local court, the general division, or potentially the district court. So the difference between those different divisions is basically the size of the debt. Small claims is up to 10,000. General claims in the local courts above 10 up to 100, district courts above 100 up to 750,000, and then if it's above that debt or you're seeking very, very particular types of legal orders, you may well have to go to the Supreme Court. Once you get judgment, and judgment can happen often with debt recovery by what's called by default, that is, they don't actually file a defence, you can then have multiple options in terms of enforcing your judgment. Some simple enforcement steps are garnishee orders. So if you know their bank account details, you can garnishee the bank and they have to pay, because a bank account is effectively a debt owed by the bank to the customer. The bank then have to, by order of the court, pay that sum of money for the judgment to you. You can garnishee wages if it's an employee who owes you money. And you can also do other things like get the sheriff to repossess their property. That's called a writ of levy on property, where they'll come in, inspect, tag items of property, and then potentially sell them at public auction to recover the debt. You can then get through to very, very technical types of recovery. Once you've got your judgment from the court. For corporations, companies, you can use creditors' statutory demands, which, if not complied with, are a deemed act of insolvency, which could then lead to the winding up of the company. And for individuals, you've got bankruptcy notices, which of course could potentially lead to them then becoming bankrupt. The purpose of the discussion today is not to get too much into the legal technicalities, other than to tell you that if you get steps 1 through to 3 right, you will then have lots of different options at step 4 when looking to recover the debt, and it'll be quicker, cheaper and easier. Okay, so whether you recover it, well, it really depends on, or whether you formally recover it and pursue it in legal proceedings or not. It's very much a case-by-case analysis. You've got to look at the size of the debt, the type of debtor, whether they're already in liquidation, what the scenario might be. But if you've got all those tools in place, then you will be in the best possible position to try and recover those debts. Okay, so that's the end of the formal presentation this morning, and I can see that there is one particular question here, so I'll just have a quick look at it. So it's about accepting smaller payments to pay off a debt in instalments, whether or not that is admitting to a preferential payment if they go broke, or is it outweighed by the number of times you accept to the number who actually go broke? Yes, so the question there, I think, is if you are taking payment by instalments and then the client subsequently goes into, for example, for a company liquidation, whether or not you're exposing yourself to a preferential payment claim. And that's a situation where a liquidator comes in and says, you were paid outside of the ordinary terms of business by this particular creditor. We are going to recoup those monies from you because they actually should form a pool of the assets that the liquidator then gets to deal with. Look, it's not bulletproof. That is a potential, and slow paying clients should be on your radar in relation to, hang on a minute, are they actually a financially viable business? The actual acceptance of payment by instalments itself is not automatically going to mean that you are at risk of having a preferential payment claim made against you by a liquidator, and the instances of that occurring are so low that as a business operator, I would always accept payments by way of a written instalment agreement from a client than compared to saying no simply because of the risk of a preferential payment claim being made by a liquidator. So it's not impossible that having accepted instalments from a customer might open you up, but that doesn't change the fact that even if they paid you in a lump sum and they were in financial difficulty, that if there was something unusual about how they paid you compared to their other debtors, their other creditors, how that might be treated by a liquidator. That is a fairly complicated area of law that we obviously can't deal with in detail, but my short answer to the question is I wouldn't refuse instalment payments based on that risk alone. Okay, so just to recap what we spoke about this morning, the core tips and tricks to improving cash flow and hopefully ultimately avoiding bad debts. Effective customer engagement processes, having a good set of terms and conditions, so being able to enforce the way in which you do business with clients, manageable and consistent collection or invoicing and collection processes, and then if you've done all of that, recovering the debt from the customer or the client. Okay, so thank you for your attendance this morning. Hopefully that you have all got something of value out of the presentation. As you can see up on the screen right now, what we've done to try and help people do a bit of a self-assessment of where they're at with their cash flow and debt collection processes and their various systems in place is this 9-point questionnaire. We'll send you this via email as well. And if you send back your answers today, we will book you in for a free half-hour consult to discuss the results of that particular questionnaire. It's really a quick snapshot of if you're not doing one of these things, there is a potential leakage there, either in relation to your cash flow or collection of bad debts. They're all fairly simple issues, things that we've spoken about today. It's not necessarily going to be an expensive process to get them fixed up. It's just making sure that they're on your radar. So have a look at them and send back your answers to us. And as I said, we can book in that free half-hour consult to go through your particular situation. Other than that, thank you very much for joining us today. I hope it was insightful and useful for you. We'll send you the information at the conclusion of the webinar. Don't forget to email back your debt health check answers. Keep an eye out for the next instalment of our Better Business Learning series. And of course, if you found it helpful, please do pass it on and share it with your colleagues. Thanks again for joining us and enjoy the rest of your day.